It's great to welcome to the program today Thom Hartmann, who's host of the Thom Hartmann program and also author of the new book out today, The Hidden History of the Supreme Court and the Betrayal of America. Very timely release. Thom, so great to have you today.
Hey, David, it's always a pleasure to be on your program. Thank you.
So just to start with, what's your process when you do a new book? Because you've done a number of them. I would guess more than 20 at this point, although I don't have the full list in front of me. Do you get an idea and then you start to do some initial research? What's the sort of process that you go through when you work on a new book project?
I've always likened it to pregnancy. I get fertilized essentially with an idea. And in the case of this book, it was back in probably 97, 98, right around 2000. Louise and I bought a house in Vermont, and in the attic over the carriage house, there was an old water-stained, essentially ruined collection of the 1909 publication, the first time that Thomas Jefferson's complete works had ever been published. And I spent the next year and a half reading that and kept finding his just raving, ranting references to John Marshall and the Supreme Court and the Marbury decision. So that was the beginning of it. And then, it kind of gestates over the years. I wrote parts of this into Unequal Protection, a book I published in 2000. But, when we came up with this idea for a series of relatively small and short books, I really wanted to go back and do a deep dive on this topic. And so and as I started writing, it just became more and more urgent until finally it was like, oh my God, I got to get this thing out. And the book is now out, and it's pretty wide ranging. And I think there's some real shockers and ahas in this book for people.
Yeah, I mean, just in thinking of if this was first an idea years ago, the way in which the Supreme Court has changed over the period of time that you've been thinking about this book, and the way that it's now affecting day-to-day the lives of day-to-day Americans has changed pretty drastically in a sense. I mean, what if we go back to the very beginning, what was the initial purpose of the Supreme Court envisioned to be?
Well, as the Constitution lays it out, and as you can read in Madison's notes on the Constitutional Convention, the court basically had two purposes. One was to have primary jurisdiction, in other words, be the first court that you go to for things like disputes between the states, disputes between the United States, the federal government and individual states, disputes between the federal government and foreign countries, and certain parts of maritime law. And then secondly, it had appellate jurisdiction. In other words, it's the court that you appeal things to as basically where the buck stops, the final court of appeals. So, if two people get into a legal dispute and one wins, but the other appeals, and then they win and the other appeals, and it goes back and forth and back and forth, the buck's got to stop somewhere, and the whole point of that was the Supreme Court. And Article 3, Section 2 makes that pretty clear.
And how has that become very different from the purpose or the position that the Supreme Court has today?
Well, there's this thing called judicial review, which is the ability of a court, in this case the Supreme Court, to determine that a law is or is not in compliance with the Constitution, which is the supreme law of the land. And if you read Hamilton's notes, Hamilton's the Federalist Papers, the articles that they published in 1788 trying to sell the new Constitution to the American people. In several of his, there's I believe 4 of them that he wrote about the court system and the Supreme Court specifically. And in several of them, he just comes right out and says, the Supreme Court will not have the power to strike down laws. Not quite in those words, but it's fairly clear. But in another place in one of them, he says, well, maybe they will. And there was no consensus among the founders on this, or among the framers of the Constitution. There was a lot of debate about it, and it was never resolved. And so from 1797, when the Constitution was ratified, or 1787, 1789, when we officially became what we are now, until 1803, there was basically, the court was seen as simply the court of final appeals. And then in 1803, in the Marbury versus Madison case, John Marshall, the Chief Justice, who John Adams had put on the court the day that he left office as a slap in the face of Thomas Jefferson. Marshall was Jefferson's third cousin, and they hated each other, and he was a high Federalist. So Adams at that point hated Jefferson, and vice versa. So anyhow, John Marshall said, I'm going to strike down parts of the Judiciary Act of 1797. And Jefferson went nuts. He said, if this decision stands, then the Constitution has become a thing of wax to be molded in the hands of the judiciary. And under this construction, the Constitution has become a felo de se, which is Latin for a suicide pact. And this decision makes the Supreme Court, the most despotic of the three branches, whereas Hamilton in the Federalist Papers had said that the Supreme Court was the least likely to offend. They have neither the power of the purse, which is the legislature, nor the power of the sword, which is the executive branch, the presidency. And so it really flipped American jurisprudence on its head. It created such a firestorm, and Jefferson was so outraged that the court basically didn't do this again for another 40 years, 50 years. In fact, 53 years. It was in 1856, the second time that the Supreme Court, in a big way, used judicial review to when Roger Taney was the Chief Justice, when he decided that he would once and for all settle the slavery issue in a decision called Dred Scott. And that decision, of course, led us right into the Civil War. So those were the only two times that the Supreme Court in the first 60, 70 years of America, 80 years of America in history, used this power. Now the Supreme Court uses it in almost every single decision. And so they really have, we flipped from being basically a democratic constitutional democracy to essentially a constitutional monarchy, which is what Jefferson pointed out back in the day, where the monarchs are the unelected, lifetime appointed members of the Supreme Court.
So to think about some of the decisions that were made by judicial review. So if we think about Brown v. Board of Education, Roe v. Wade, the 2015 gay marriage decision, to sort of like a modern left-winger who casually follows politics, you might see those decisions and say, I like the outcome, so therefore maybe this judicial review thing isn't quite so bad. The two questions I have on that are, number one, should we be evaluating this on the basis of particular decisions that we do or don't like? And then number two, are those maybe good decisions from the point of view of a modern American leftist outweighed by other bad decisions?
Right. Well, first of all, there have been far more bad decisions than good decisions from the point of view of a leftist, from destroying union rights to destroying civil rights to destroying voting rights. The Supreme Court has consistently for largely since the 1880s, the 1870s, as Reconstruction was falling apart, almost always, with the exception of a short period after Franklin Roosevelt's administration, during and after, has ruled on the side of corporations and very, very wealthy individuals. I mean, it's just very straightforward. In terms of the decisions that you mentioned, just to take Roe v. Wade, for example, because there's a chapter about that in my book, and people like to point to that. In 1961, the birth control pill was legalized. It was, the FDA approved it. By 65, the birth control pill was in widespread use across the United States, as were other methods of birth control. And in the Griswold v. Connecticut decision, the Supreme Court struck down the Connecticut state law against even married couples having any kind of birth control, including condoms, in their house. It was illegal in Connecticut up until 1965. And then birth control became very, very widespread. New devices were coming out. And so by the early 1970s, the women's movement was really, really picking up steam. Women's rights in the workplace, women's rights, the right of women to control their own reproductive functions, their bodily functions and whatnot. And so what the Roe decision did, and then the subsequent Planned Parenthood v. Casey, where they came up with the whole 3-trimester idea, which is really something that the legislature should do. What the Roe decision did is public opinion was rapidly moving in the direction of abortion being legal. And had Roe not been decided the way it was, there's a pretty broad consensus. And I've had this conversation with a number of, fairly high-profile feminists, people whose names you'd recognize. I mean, you can find them on our website. There was a fairly broad consensus that within a decade or so, abortion would be legalized, at least in most states across the United States, and the pressure would build eventually. By short-circuiting that in 73 with the Roe decision, you could make the argument, and I think I do well in the book, that really what that decision did is it created a reactionary backlash And that reactionary backlash has led to the death of a number of abortion doctors, the general harassment of women all across the country, shutting down abortion facilities, now shutting down Planned Parenthood facilities that don't even offer abortion. As a result, we're seeing rates of cervical and uterine cancer start to increase in these states where this is happening. Had it been through the legislative process, there wouldn't have been a dispute about its legitimacy. I would say there was a similar trend with Brown in 1954. Now, you could make the case in both cases, in 54 with African Americans and in 73 with women, that had the Supreme Court not decided in that way, and if it did take another decade or so for public opinion to catch up to the point where everything got decided, that a lot of people would have gotten hurt. And I would agree with that. But I think that the consequence of the court intervening in these ways is broadly not helpful.
That's interesting. So to take the Roe v. Wade example specifically, the idea is if instead of a Supreme Court decision in 1973 legalizing abortion, you saw states do it individually from the period starting in 73 and ending in 83, just to pick a 10-year period.
Well, they already were in the starting.
Right. So it actually started earlier in a sense. But so there was a 10-year period there that you would have ended up with very similar legalization, but with less political controversy that might have avoided much of the anti-choice activism of the 40 years that followed.
That's correct, because the main claim of the forced pregnancy crowd is we got screwed by the Supreme Court. The kings and queens made a decision and we had no say in it. And that's a legitimate complaint, frankly. And I would say that's a legitimate complaint for people like you and me to say, the Supreme Court gutted the Voting Rights Act that passed the Senate unanimously.
Right. Now, if you zoom out a little bit, you mentioned corporations versus individuals. If you had to summarize the gist of how the Supreme Court has decided over the last 50 years, is that the most notable way that you would categorize it, in favor of a large corporation versus in favor of the individual? Or is there some other lens that is maybe even more relevant or precise?
Well, the court has typically been on the side of property and power. And to a certain extent, that's a result of it's basically a conservative institution. I don't mean in the political sense. I mean in the, slow motion, cautious, although some of these decisions, overturning the Voting Rights Act, for example, are pretty radical. But, and you could argue Brown and Roe were as well. But, the Supreme Court is basically that, number one. Number two, at the time that the Constitution was constructed, the hot new things in the landscape of the Enlightenment thinkers, and certainly the founders and framers were on the tail end of the Enlightenment, which arguably started 100 years earlier when John Locke wrote some 2 treatises on government, and said people should have the right to life, liberty, and private property. Private property was a relatively new thing, at least for commoners. I mean, it still wasn't a thing for women or people of color. In fact, it wasn't a thing for women until the 1970s in the United States. In 1973, I had to co-sign my wife's application for a credit card because women were not allowed to have them in their own names without their husband's or father's permission. But, in any case, for white men, property rights was a big deal in the 1600s. That the king no longer owned your underwear and your wife and your house and everything else. And by the 1700s, by the 1770s, property rights were pretty much accepted. But it was the new thing, that and human rights, civil rights, which is what the Bill of Rights was. But there was no consideration of the rights of the environment, because the environment seemed to be vast and limitless. And, who cares how much junk goes into the rivers? It doesn't matter. And that's one of the problems that we have to address right now, and it is being addressed in part by this Juliana case before the Supreme Court, which is also mentioned in the book. And if I could just close the loop on our earlier conversation about judicial review, after Jefferson went nuts about the Marbury decision, one of his friends, and I'd have to look in my own book and see who wrote the letter to him. I think it might have been it might have been Mr. Mason. But in any case, one of his friends wrote him a letter saying, if you don't think that the Supreme Court should be the arbiter of what is constitutional and what is not constitutional, who should be? And Jefferson wrote back and said, the people themselves. And then he explained, and by the way, that phrase is the title of a book by Larry Kramer, the former dean of the Stanford Law School, that is a brilliant critique of judicial review. The point, and people will say to me, well, what if Congress passed a law saying that if you speak ill of the president, he can put you in prison? Isn't that a clear violation of First Amendment rights of free speech? And shouldn't the Supreme Court intervene immediately? And my answer is the same as Jefferson's answer was in 1804, is that in 1798, John Adams passed just that law, the Alien and Sedition Act. And the day that he signed that law, he put Ben Franklin's grandson, Benjamin Franklin Bach, who published a newspaper in Massachusetts called the Aurora, put him in prison. And in prison for writing an op-ed in which Benjamin Franklin Bach said that John Adams was, quote, or there's a paraphrase, but it's close to an exact quote, old, toothless, querulous, and balding. A fellow by the name of Luther Baldwin was sitting in a bar in Newark, New Jersey, when John Adams and his wife Abigail came through town in their carriage, and they had mandated that whenever they came through a town, the military had to come out and do a 21-gun salute. And Baldwin said to the bartender, there goes President Adams. They're shooting the cannons. I hope they shoot him in the arse. And he didn't know that the bar owner was a Federalist who turned him into John Adams. John Adams had him thrown in prison. I mean, 20 newspapers were shut down. Matthew Lyon on the floor of the House of Representatives got in a fight with Roger Griswold, the Connecticut representative, over this issue. And John Adams had him shipped off to an unheated jail cell in Vergennes, Vermont for 2 years. He ran for re-election in the election of 1800 and won his seat back. The Supreme Court never intervened. What killed the Alien Sedition Act, this insanely unconstitutional law, the thing that created the schism between Jefferson and Adams that was so great. I mean, Jefferson left town the day it was signed and literally never talked to Adams in person again. The thing that fixed that was the election of 1800. It was the people themselves. So ultimately, either, and this is what Jefferson was arguing, either we believe in democracy or we don't. If we want to try and create a constitutional monarchy, then yeah, make the monarchs the Supreme Court justices. It's better than a hereditary family, and give them final say over everything. But if you want to have an actual constitutional democracy, then the people have to be the ones who make the decisions.
The book is out today. It's called The Hidden History of the Supreme Court and the Betrayal of America. I was lucky enough to get an early copy. We've been speaking with the book's author, Thom Hartmann. Thom, so great to have you on today.
Thank you, David. Great talking with you.